On this afternoon's calendar is Solomon Vincent Hester versus the state, case number S12A1829.
Brett Willis for appellant, Benjamin Pierman for appellee.
Mr. Willis.
Madam Chief Justice, may it please the court. Solomon Hester appeals the trial court's denial of his motion for a new trial owing to the state's failure to disclose not one but two toxicology tests that were performed on the deceased blood by the Georgia Bureau of Investigations, both of which located and quantified the presence of the marijuana metabolite. Mr. Hester.
They were both negative, though, weren't they?
No, Your Honor, I disagree.
One was inconclusive, the other was negative.
No, sir, I disagree. The first test is an immunoassay, what the GBI calls a screening test, but is a valid, admissible, scientifically acceptable test, and it was a hit. It was what GBI calls an indicative, but it's a hit. It was a positive. It was a positive, even though it was a 17-month-old blood sample. And there's a lot of discussion about dissipation and degradation of a blood sample once it's taken in. It was shocking, according to the defense expert at the motion for new trial, to see anything at all in this very old blood. But it was a located immunoassay hit for the metabolite. It was not a negative. Now, GBI policy says, and this is only GBI policy as of today. In the old days, GBI would use that test as a positive. They were using that test at trial against defendants to suggest that an individual was under the influence of marijuana, and that test alone. Now, GBI, what they do is they use it as a screening test. They use it as a preliminary test.
They were using that test with that result?
They were
using that type of test with results that were stronger than that?
Justice Nami, it's not entirely clear, is the short answer. That's always been their cutoff. And in fact, I think you can see a discussion of this in the Love opinion, which is ironically cited by the appellee in their brief. 25 has always been the cutoff. You can see that in the Love opinion where this court addressed the marijuana metabolite DUI statute and struck it down ultimately, but found it was rational to prohibit driving with a metabolite. The cutoff was 25 there as well. So this is a hit. This is a hit, and it didn't take into account the dissipation of the sample. That's just the first test, okay? And that test was conveyed to the prosecution explicitly and expressly by phone call 3 days prior to the beginning of the trial.
And was it revealed to your client at trial?
It was not. No, sir. It was never revealed to my client. It was never revealed to defense counsel. We simply never learned of any result that was completed or that was even conducted. We proceeded through the trial. We cross-examined every witness, including the GBI's toxicology expert who testified about the alcohol. We also had the medical examiner come and testify. He was cross-examined only about alcohol. We didn't know anything about a completed test.
So when the trial court says that the test was completed during jury selection and the fact that further testing was needed conveyed to the state, none of that was passed on?
Absolutely correct. It was not passed on. We were not told. That's really uncontroverted. And this is in the face of an explicit request by Mr. Hester to have the blood tested for the immunoassay, what GBI calls a screening test. We asked the GBI to do the test. The GBI refused unless there was going to be a request from the prosecution or a trial court order. And the trial court ordered the test be done. The GBI completed not just that first test, but did an additional test. And the additional test also located and quantified the marijuana metabolite. And this is where we get into really what our position is. This should have been a jury question as to what the proper interpretation of the two samples was. Under GBI policy, if you have a second test, which is the GCMS, if the second test is below 10 nanograms per milliliter, then that means that both tests are negative under GBI policy. And we don't contest that's GBI's policy, but it didn't take into account the dissipation of the sample at all, not one bit. It didn't take into account that both the GCMS and the IA had a hit. And it also doesn't look at the factors that suggest really marijuana intoxication on the part of the deceased in this case. So we have two tests, both are hits, and Mr. Hester was informed of neither test.
How would a prosecutor whose experts from the GBI crime lab, who as I understand it were the only experts till you came along on motion for new trial, and his experts say this is a inconclusive test, we're going to do more, and then says this is a negative test. How is the prosecutor reasonably supposed to know that somewhere out there there's an expert that can be dug up to interpret the test to say that they are not negative or inconclusive?
They're not required to do that, but that's not what we're saying. What we're saying is not that the GBI's conclusions were the Brady evidence, Your Honor. The GBI's conclusions are not the Brady evidence. What was the Brady evidence? It was the results of the tests.
So by your logic, even if the tests were negative according to the GBI, the FBI, and every other forensic society in the world, but you could find an expert who would say, well, I think a 0.001, is arguably positive, that would be Brady material.
The results should be conveyed to the accused only if, and I want to be very clear about this, only if and especially in situations just like this case, where the accused has made a specific, express request.
Well, that doesn't,
for that test.
I never prosecuted a case where the defense didn't ask for all Brady material. And the law of Brady is generally that it doesn't, it's nice to have a specific request, but the Brady obligation doesn't change a whit whether it's specific or not. So you can say only when it's a specific request, but every case where you say I want all the testing results, you're saying you get them whether or not the prosecutor or the experts say that they are material.
What we're saying, Justice Namias, is, and we're aware that Brady no longer requires an explicit request. We're aware of that. We're not saying that that's somehow gets us, that that's an element of the Brady claim. We know that it doesn't require an express request, but when one is actually made, then the prosecution's on notice. Then the GBI is on notice that we want this test. We went to the trial court and got an order saying, do this test. They did both of the tests, and they didn't tell us. And Justice Namias, also, to follow up with what your hypothetical, this is not a case where our toxicologist posited something that's completely unreasonable about the proper interpretation for these two test results. This is not that case at all. And
so the standard is if the prosecutor has to find out reasonably whether or not that the experts from the forensic lab are saying this is a negative test, but the prosecutor has to somehow independently figure out if what the forensic lab's telling him is in fact good expert.
Well, in this case, it's moot, and here's why. Because, Justice Namias, this is the telephone call that the prosecutor actually received from the toxicologist himself. It said we have an indicative, or they didn't use the word positive, but we have an indicative result. And, quote, we don't know if we're going to be able to rule it out very well or confirm it. So this is not the speculative case. This is not the case where the prosecutor has to have divine knowledge of all the science and have, to do that investigation. This is the case where the prosecution is specifically told repeatedly, where an order is actually granted to do the test, and the prosecutor is told by telephone call, you've got a hit. And the trial's beginning in 3 days They know we're waiting on it, and we don't hear a word, not once, but twice. That's what this case is. And it's also the case where what the toxicologist that we called at the motion for new trial, we were trying to really show what we could have done. The toxicologist we called gave an opinion that's not outside of the bounds of reasonableness. We know that because you can look at the GBI expert's testimony. We can look at what GBI expert Larry Llewellyn said. If this is marijuana, he says, now it's below the 10, so I'm not willing to say it's marijuana, but if it's marijuana, then marijuana intoxication is a reasonable interpretation of this sample. And he even went further than that. I gave him a hypothetical from the case. And I said, let's assume that this is marijuana like your GCMS test said it was, like your IA test said it was. Is it possible that this sample supports this conclusion? That Mr. Hester comes home from work, leaves, his girlfriend smokes marijuana, gets high, he comes back, and she's intoxicated on marijuana, and this is the result. Does this result support that? And he said yes, if this is marijuana. This is not a speculative case. Now, this afternoon I was hoping to discuss,
Mr. Pittman.
really, yes, sir.
It came back, the expert said that the test was negative, didn't they?
The GBI experts,
Well, and your expert testified, defendant's expert testified that the GBI followed its protocol, right?
correct, exactly, but that's irrelevant. The GBI's protocol doesn't take into account dissipation of the sample, and that's the critical.
Your argument is that it was effectively a positive, is that what you're arguing?
Unequivocally, yes, Justice Hines. This is a positive test. Unequivocally, yes. And you can look at the testimony from Denise Childers, who's the GBI toxicologist, in addition to the defense toxicologist who testified. She says, and she acknowledges, treatises, books, learned treatises all acknowledge this metabolite dissipates incredibly quickly when it comes in. It's dropping, dropping, dropping as it comes in. GBI doesn't even test blood that's over 12 months old. They throw them away. This blood here was 17 months old. And according to my expert, the result was likely through the roof. Likely through the roof, much higher when it came in. And so I asked both of the GBI toxicologists at the motion for new trial, isn't it possible that if it had been tested when it came in, it would have been a positive, even under GBI standards? And they both unequivocally said, yes, absolutely. And the question here is, really, it's got to relate back to her intoxication. GBI would have called it a positive if it had been tested when it came in, but under GBI standards, they don't test a decedent's blood in a death case for marijuana. They test defendants, but they don't test the decedents. So we had to go for an order to get it. This is a positive test. And to the extent that there is a reasonable scientific debate about the appropriate interpretation for these tests, that's a matter that should have been for the jury. The jury had a right to hear that she was under the influence of marijuana. If the state wanted to present a toxicologist to argue why we should ignore the dissipation and degradation of the sample, then that's what they should have done to the jury. And that gets me to what I wanted to talk about today, which is the materiality of this evidence, why it would have mattered. This case is a circumstantial evidence case. It's as close as it can get in a murder case. Every single piece of evidence that the state put out there was rebutted by the defendant at trial. They had a blood spatter expert, we had one. They had a medical examiner, and we had one. They had, they had a gunshot residue expert. We had a plausible explanation for the gunshot residue found on his shirt. It's consistent with the story. Every thrust was Perry. That's what this case was. It was that close. No prior difficulties are introduced between the deceased and Mr. Hester. And we've got this erratic, strange behavior, which her daughter testifies about, crying about where her dead mother is buried, saying her heart hurt, crying up and down the halls. Her daughter overhears her making that statement about her heart hurting and where is her dead mother buried. This strange behavior. that really, this was a very close case. And to reach the reasonable probability standard, it doesn't take much in this case, frankly, because it was that close, as the state conceded in their closing argument. This is just a circumstantial evidence case, and it was very, very close. So look at what the marijuana intoxication would have given us to attack the state's main theories, their circumstantial pieces. The lighter that's still gripped in her right hand. We know marijuana causes divided attention where the left hand doesn't know what the right hand is doing. Pistol in left hand, lighter in the right hand. Very unexplainable without intoxication. It makes no sense. Why does a person shoot themselves while they're holding a lighter? Well, we know that marijuana intoxication leads specifically to divided attention. That's what it does. We know that. Left doesn't know what the right is doing. And our expert testified that that's actually observable in something called BIC syndrome in marijuana users. They have a lighter in their hand, they'll flick it. That's what marijuana users exhibit. Jury never heard about that. The statement that Ms. Brownell makes shortly before the shot that implies Mr. Hester was somehow attacking her or coming after her. If you put your hands on me, I'll call the cops. The jury never learned that marijuana is a hallucinogen causing people to see and relate facts that simply are not true. Combine that with the really incredibly elevated blood alcohol level of 0.27 that the deceased had, and we've got not merely additive, but we've got exponential effects. The jury should have heard about that, especially in this very close case. The awkwardness of the trajectory of the shot and the wound or weapon orientation, this is reproduced in the briefs. Basically, the pistol was like this, which is, as they said, awkward or uncomfortable for a person to do normally. Awkward, more comfortable to have it like this. But it was a muzzle stamp like that. And the trajectory goes like this through the couch. Awkward, very strange for a person to do normally if they're not significantly and severely impaired. We know marijuana causes that, not merely additively, but exponentially. This is a very close case. I did want to reserve the remainder of my time, and at that time, maybe we can address some of the diligence questions if they do arise. Thank you.
Counsel. Mr. Pierman.
Thank you, Madam Chief Justice. May it please the court. I represent the state in this matter, and we are the appellee. We ask that this court please affirm appellant's convictions and sentences for murder and other related crimes. First off, Your Honors, I would like to briefly correct or at least be a little more specific in our language today. Counsel for appellant has used the word hit and has said the word positive several times. I think because of the factual scientific nature of this case, I think specificity behooves every party involved here. There was never a positive test for marijuana in this victim. In fact, the GBI toxicologist, Larry Llewellyn, said specifically that he would have never said the word positive. He would have said the word indicative. And indicative and positive are similar, but they are different, and the difference is key in this case, Your Honors. Further, appellant has argued that the dissipation of the sample due to the age of the sample, i.e. that the level of marijuana metabolites of the THC in the victim's blood would naturally have dissipated and would have fallen throughout the time from when it was taken to when it was actually tested. I would like to just go ahead and submit that the dissipation was entirely as a result of appellant's failure to ask for the tests to be performed on the victim's blood for marijuana for almost an entire year. Turning now to my argument in chief, as this court is well aware, for appellant to be able to show that his rights were violated when the state failed to turn over evidence in violation of Brady v. Maryland, the appellant must show that the evidence was favorable to the accused because it's either exculpatory or impeaching, that the evidence must have been suppressed by the state, and that the the defendant could not and did not possess the evidence through the exercise of reasonable diligence, and finally that the defendant, the appellant in this case, was in fact prejudiced by this. And it is the state's position that the appellant fails in every single prong of the Brady analysis. Taking them in order, Your Honors. The evidence was not favorable to appellant. Several members of this honorable court today have seized upon the fact that the tests were inconclusive. The tests were inconclusive. First of all, the IA, or the immunoassay test, came in directly at the threshold where if it had been any lower quantifiably, the GBI would have reported that the victim's blood was negative for marijuana. Any higher, and then it would have, they would have said positive or indicative for marijuana.
You know the chronology of the reporting of these tests?
Absolutely, Your Honor.
How about give us a timeline through when the test, the defendant announced ready for trial at some point, made a motion for these tests. When were the tests conducted and when were the results known? When were they reported?
Thank you, Justice Thompson. That's an excellent question. The tests were first the tests were first requested by appellant's counsel, trial counsel, on March the 3rd of 2009. That was when the hearing was held. The final pretrial hearing was held, and he asked, I would like for the victim's blood to be tested for the presence or lack thereof of marijuana. On or about March 6th, the very beginning of trial, I believe it was still during the voir dire period of trial, the tests were began, and and that was the immunoassay, the IA, or the screening test. And I believe it's at trial page 374, where the prosecutor states that the test has been the IA test, the screening test, has been accomplished, and that the results indicate that further tests are needed. And this is a very important distinction here. There has been, frankly, there has been argument to the contrary, but the record shows at the motion for new trial page 65 and 68 through 69, where Mr. Llewellyn, the GBI toxicologist who performed this immunoassay or screening test, testified at the motion for new trial that on that day he called the prosecutor and it informed her that the test was at the cutoff, so that he was unable to say if the victim was positive or negative for marijuana, that it was indicative for marijuana. Thus, the more accurate GC-MS test was going to have to be required. And most importantly, in that record excerpt that I just cited to this court, motion for new trial 65 and 68 through 69, GBI toxicologist Larry Llewellyn testified that he also informed petitioners, I keep saying petitioner, it's habit, that appellant's trial counsel was also informed, that he called appellant's trial counsel and said that he had performed the IA test and that the results of the IA screening test indicated that there was further testing needed, i.e. the GC-MS test. So, and then to complete the timeline, Justice Thompson, then the GBI put a rush. They knew that this test was needed to be completed before the end of trial, and they were able to complete the GC-MS test. And when I say complete, the record indicates that the test is done, but then, like all scientific research, it has to undergo a period of peer review by other scientists, other technicians, to look and to verify or question the validity of said test, and that's just a foundation of all scientific research. But regardless, the results of the GC-MS test were released to the prosecution on March 19th via a secure web service. And
you're not arguing that the indicative result is not Brady material. You're saying, or are you?
Your Honor, Justice Melton, the indicative test is not Brady material because it is not in any way exculpatory or impeachment evidence. Therefore, it's not favorable to the appellant, because all the indicative test says is that we are, and this is replete for the record, and toxicologist Llewellyn was very specific. All the IA, the screening test, said was that the victim's blood was indicative for the presence of marijuana metabolite. Now, all that means is that the GBI, through the best scientific methods they were able to test the blood on with, was that they could not rule out, nor could they rule in, the presence of marijuana metabolites within the blood. And if that's the test, then that is simply not Brady material, because I fail to see how a test that cannot rule out, nor can it rule in, the presence of marijuana in the victim's blood be considered favorable to the defense.
Well, it was not. It was revealed to the defense.
Your Honor, there is evidence at the motion for new trial, Justice Thompson, that toxicologist Llewellyn called on the telephone, called on or about March 6th, called both the prosecutor and called trial counsel for the appellant and informed them of the results of the IA screening test. That is in the record.
When was the result of the gas chromatograph revealed?
That was released to the state on March 19th via the secure web service, but the defense had arrested its case in chief, and in fact evidence had closed in the trial the day before on March 18th.
Had a verdict been rendered at that time?
No, Justice Thompson. A verdict had not been rendered. I believe there still needed to be jury charge and closing argument.
And when, if ever, was it revealed to the defense, the result of that test?
I believe the defense obtained that information via subpoena after trial, but before the motion for new trial had started. But the fact of the matter is the evidentiary phase of the trial had been completed prior to the to the test, the GCMS test, which, of course, as members of this court have already seized upon today, was wholly negative for marijuana. I believe it came in at a 7.5, and 10 is and it's nanograms or some very minuscule amount. It came in underneath the threshold for where the GBI will declare someone's blood to be positive for the presence of marijuana metabolites. So again, the more accurate, the more specific, the more rigorous test shows that the victim did not have enough marijuana metabolite in her blood to be considered positive for the drug. Thus, Your Honor, and that is important because the timeline is, and the evidence, and then my preceding argument is part of the test that appellant must satisfy in order to show that a Brady violation has occurred, and that's that the state suppressed the evidence. And I think the record in this case, it's my position that the record in this case indicates that there was no suppression, because all along the way the state kept appellant apprised of the progress of the testing of the blood. And as I've mentioned earlier, neither one of these tests is favorable to the appellant in any way. Third, Your Honors, appellant was not reasonably diligent in pursuing this blood evidence, the evidence of marijuana in the victim's blood. And again, Justice Thompson, kind of dovetailing into your question, this is because on or about March 21st or 31st, the record is unclear, but regardless, in late March of 2008, almost exactly a full calendar year before the commencement of trial, appellant's trial counsel, and appellant was served with the bulk of the scientific evidence in this case. And in that discovery was the fact that the state tested the victim's blood for alcohol, for cocaine, and for amphetamine. So in late March of 2008, almost a calendar year prior to the commencement of trial in this case, appellant was aware that the state had tested the victim's blood for alcohol, cocaine, or amphetamine. And that was it. Appellant was aware for a year that the victim's blood had not been tested for the presence or lack thereof of marijuana metabolites. So appellant had this information for almost a full calendar year, and yet waited until 3 days before trial to ask the trial court to have the state expend its additional resources and test the victim's blood for marijuana. There is a limited amount of precedent addressing this prong in Brady analysis in this court, but I submit to this court that cannot be called reasonable diligence in obtaining this evidence. Appellant knew for a year that the victim had not been tested for the presence or lack thereof of marijuana metabolites, and appellant did nothing. The fact, so I think the record is quite clear that appellant was not in any way, shape, or form reasonably diligent in pursuing this evidence. And finally, Your Honors, appellant cannot show that there's a reasonable probability that the outcome of the trial would have been different. That is, of course, to say that appellant cannot show that he was prejudiced in any way, shape, or form by the lack of this testing, or by the fact that he was not given the immunoassay test results or the GCMS test results before the end of trial. And that's simply because, contrary to appellant's argument in briefs and here today, the fact that the victim, even if you take the appellant's defense expert at face value, that the victim did smoke marijuana 4 to 5 hours prior to her death, to her murder, and he's the only expert who stated that. The GBI toxicologists weren't able to quantify at all whether or not or when the victim last smoked marijuana. That information, that evidence is merely cumulative of the fact that the jury heard and was well aware of the fact that the victim registered a 0.27 blood alcohol content, which is over 3 times the legal limit for driving in the state of Georgia. So the jury was well aware that the victim was not just drunk, was 3 times the legal limit for being drunk to drive an automobile in the state of Georgia. Further, the jury heard through the cross-examination of a state's witness that the victim would have been in an exaggerated emotional state. She would have been staggering. She would have been confused. She would have been disoriented, and she quite possibly could have been vomiting based on the high level of intoxication she had from her alcohol intake that evening. So, appellant's argument now that if the jury had known that not only was she incredibly drunk, as they knew, she could possibly have also been intoxicated on marijuana, then the outcome would have been different. That there's a reasonable probability that the outcome would have been different is, in my opinion, mere speculation, because it is simply additive. It is simply just tweaking the fact that the jury already knew that she was already highly intoxicated. As such, appellant has not satisfied any of the 4 prongs of the Brady analysis. The evidence is not favorable. There was no suppression by the state. Appellant was certainly not diligent in pursuing this evidence, and appellant has shown absolutely 0 prejudice accrued to him as a result of the fact that he was not aware of the immunoassay or the MCGS or GCMS test prior to the end of trial. And if there's no further questions, I would ask this court again to please affirm appellant's convictions and sentences for murder and possession of a firearm during the commission of a crime and cruelty to the children in the 3rd degree. Thank you.
Thank you, Counsel. Mr. Willis?
Very briefly, just wanted to correct a couple of issues. The GCMS test was released to the prosecution on March the 17th. That's Tuesday. Trial was going on. Evidence is open. You can see that at motion for new trial 53 and also at 70. GCS was released well before the evidence was closed. 2, was counsel for the appellant told that there was a hit on the immunoassay test by the GBI toxicologist, as stated by my brother? No. And the testimony at the motion for new trial from toxicologist Llewellyn was, quote, "He may correct me if I'm wrong, but I think I called counsel for the appellant and told him." So then I took the stand and said, no, he never phoned me. And Llewellyn admitted there's no notes in his machine that he logs his calls. So it was not conveyed. In fact, if you want to see the extent of what was told, you can look at page 374 that was cited, but I don't know if that's going to come up on your screens, but this is what we were told in court 3 days before the trial, as we're waiting for the results to know if there is a hit, to know if there's been a test actually done. This is it. This is the extent of what we're told. And that's it. There's no mention of an indicative result above the GBI's threshold. And we're not told that a test is completed. I recounted this full colloquy in my reply brief that I submitted a few weeks ago, but I'd ask you to look at that. Lastly, with respect to diligence, counsel argues that we were not diligent because we didn't ask for the test sooner. First of all, the GBI refused to do the test. We had to compel them to do the test. But more significantly, the only timing that matters. I'm sorry?
Get them to do it.
Sometime shortly before March 3rd, Your Honor. And as I testified, I wish I'd asked earlier, but that's not what the Brady claim's about. Brady claim's not, could you got the test done earlier? The only timing that matters for a Brady claim was, is the test done? And is it done before the end of the trial? Both answers here are yes. Mr. Hester and really this jury had the right to hear about this evidence, and they had the right to make a determination whether it mattered in this exceptionally close case. We'd ask the court order a new trial. Thank you.
Thank you, counsel. This court will stand recessed until 10 a.m. tomorrow morning.
All rise.